Page 9. Page 10. Page 11. Page 12. Page 13. Page 14. Page 15. Page 16. Page 17. Page 18. Honorable members, in the absence of any further corrections, the votes and proceedings of the 10th sitting dated Wednesday, 26 June 2024 are adopted as a true record of proceedings. Honorable members have a copy of any Hansard with me, so we'll proceed on to recognize some visitors to Parliament today. We have students from a number of institutions with us this afternoon. First, we have students from Okushibiede Methodist Basic School. There are 95 in number, 95, and they are from Gan West Constituency, led the head teacher in the person of Mr. Ado Ebenezer. Honorable members, they are up at the public gallery to the right side of the speaker. Please kindly acknowledge their presence, and you are warmly welcome. This is your parliament. Anytime you are welcome here. So please resume your seats. We also have students from Kuntanase Presby Basic School. There are 60 in number, 60 of them coming from the Asikuma Adobin Brakwa constituency. They are also led by their head teacher in the person of Mr. Charles Ayensu. Please, you are also welcome, and as stated, this is your house. Anytime, you'll be warmly welcome here. You may resume your seats. My brothers and sisters from the Fantland changed Ayensu to Riverson. But when we decided to Fantalize, it came back to Ayensu. Any challenger here? There's none. Yes. When we were being English, we decided Riverson should take over Ayensu, or Rivers. Now we are back to Ayensu. And I'm saying this because you know our great former clerk, in the person of KB Ayensu, has written a number of books. He was the one who led Parliament to transit from the colonial era to independent Ghana, starting with the parliamentary democracy in 1957. KB Ayensu, great man who in Nkrumah was preparing to become the clerk to the African Parliament. This you don't know. You have to be paying me for that. Yes. So, students, once again, you are welcome. And it's always a pleasure to see you here. According to the application by leaders, they will prefer that we handle questions today. Question time. Are we ready? Yes, Majority Chief Whip.
Speaker, we are ready, except to add that we have some understanding that where the questioner is not present, the answers will be published. And also following the business we've agreed to prosecute and the times, there will be one follow-up question instead per question. So that is the common understanding we have.
Honorable members, I'm sure you've heard the Majority Chief Whip, so we'll go by that rule, except otherwise decided by you. And so, honorable members, we will now call the Minister responsible for roads and highways to respond to the scheduled questions appearing on the order paper. The first question stands in the name of the Honorable Member for Pru East. Honorable Member for Pru East, Honorable Dr. Kwabena Donko. You may ask your question now.
Thank you, Mr. Speaker. Mr. Speaker, I rise to ask the Minister for Roads and Highways when remedial works will be carried out on the Ejura to Atibubu through Prime to Yeji Highway to avoid further deterioration of the highway. Thank you, Mr. Speaker.
Yes, Minister for Roads and Highways.
Thank you, Mr. Speaker. Mr. Speaker, the Ejura Atebubu-Yeji Road forms part of the interregional road IR04. It is a 113.4 kilometer long and traverses Atebubu Amantin Municipality, Pru West and Pru East districts. The road is a bituminous surface dressed and is in fair condition. There is currently no rehabilitation program on the road. Routine maintenance contracts, which is pothole patching, have been awarded on the road for the 2024 program to prevent further deterioration. The contractors are currently mobilizing to sites. Engineering works will be carried out by the end of the third quarter of 2024 to determine the appropriate periodic maintenance intervention to be carried out on the road, Mr. Speaker. The implementation of the intervention will be considered upon the availability of funds. Thank you, Mr. Speaker.
Any supplementary?
Yes, Mr. Speaker. Mr. Speaker, whilst I concede that the definition of fair is subjective, I will want to put to the minister that the road is seriously challenged. It has so deteriorated, and would the minister consider sending his technical team to go and do an assessment of the road, particularly with the rainy season setting in? Thank you, Mr. Speaker.
Yes, Minister.
Thank you, Mr. Speaker. Mr. Speaker, by the information available to the ministry, the road is considered to be fair. And I agree with you that that can be subjective. But I have a lot of respect for my senior colleague. And for him to say that we should consider, I don't think it should be something too difficult for the ministry to do. We will send people there to do further assessments, and appropriate intervention will be undertaken, subject to availability of funds. Thank you.
Yes, honorable members, we move on to the next question. Question number 1585 stands in the name of the honorable member for Nalirgu Gambaga, Honorable Mr. Seidu Isifu. Please, you may ask your question now. Well, he not be available, we'll go by the rule. It will be published. Or you have his authority? Yes, the answers will be published. We will now move to the next question, 1603. Stands in the name of the honorable member for Bole Bamboy, Honorable Mr. Yusuf Sulemana. Yusuf Sulemana is also, yes, I can see.
Yes, Mr. Speaker, thank you so much.
Tola Kalba.
Yes, Mr. Speaker.
Yes, please, okay.
I have the authority of the owner of the question to seek your permission and then to ask the
Please,
question.
granted.
All right, Mr. Speaker, thank you so much. Mr. Speaker, I rise to ask the Minister for Roads and Highways when the damaged part of the Bamboy Bolewa Road at Bombonte in the Bole district will be repaired. Thank you.
Yes, Honorable Minister.
Thank you, Mr. Speaker. Mr. Speaker, the road in question is classified as a national road, N12, and starts from Asem Krom Junction on the N1 and traverses Juaboso, Sunyane, Techima, Bamboy, Bole, and ends at Wa. The road corridor falls under the Bole Bamboy district. The Ghana Highways Authority has planned to undertake pothole and sectional repairs under the 2024 maintenance budget to prevent further deterioration. The contractor is currently mobilizing to site. In terms of the future, there is a plan to undertake rehabilitation and asphalt overlay on the Bamboy Bole road. Thank you, Mr. Speaker.
Any supplementary?
Yes, Mr. Speaker.
Yes.
Speaker, Honourable Minister, will you be kind enough to give us the name of the contractor and when exactly he'll be moving to site? Thank you.
Yes, Minister.
I believe the minister is talking about the contractor for the sectional repairs and pothole patch. That is Messrs. Adamu Denji's Company Limited, and he's currently mobilizing to site. I believe in 2 weeks' time, maximum, he should be on site work. Yeah, he should be on site work.
Honorable member, we go by the rule. That's the end of supplementary. So we move to the next question. Question number 1606 stands in the name of the honorable member from Yila Krobo, Dr. Albert Tete Nyakote. Honorable member, you may ask your question now.
Mr. Speaker, I rise to ask the Minister for Roads and Highways when work will commence on the following roads in the Yilo Krobo constituency: Sikaben to Agogo, Huhunya to Boti, and Insutapon to Opesika. Thank you, Mr. Speaker.
Yes, Minister.
Thank you, Mr. Speaker. Mr. Speaker, the Sikaben Agogo Feeder Road is a 10.2 kilometer long road. It is located in the Yolo Krobo district of the Eastern Region, and it is a bitumen surface road in poor condition. There is no upgrading or rehabilitation program on the road now. Engineering studies will be conducted on the road by the end of the fourth quarter of 2024 for upgrading. The execution of the west will be considered under the 2025 budget. Just because the Hununya Boti Feeder Road is a 31.4 kilometer long road. It is located in the Yolo Krobo district of the Eastern Region, and it is a bitumen surface road in poor condition. There is currently no program on the road. However, as engineering studies will be conducted on the road by the end of the fourth quarter for upgrading. The execution of the west will be considered under the 2025 budget. The Insutapon Opesika Road is also a 4.5 kilometer road located in the Yolo Krobo district of the Eastern Region. The roads are gravel surface in poor condition. There is currently no program on the road. However, engineering studies will be conducted on the road by the end of the fourth quarter of 2024 for upgrading. The execution of west will be considered under the 2025 budget. Thank you, Mr. Speaker.
Any supplementary question?
Yes, Mr. Speaker, I have a supplementary question. Mr. Speaker, I asked this very question in July 2020, and the response is similar to the response I have now. The Honorable Minister said engineering works will be done end of fourth quarter 2021, and then the execution will be in 2022. I'm getting the same answer now 2024 and 2025. How sure are we that this is being taken seriously? Thank you, Mr. Speaker.
Yes, Minister.
Mr. Speaker, I'm sorry, I didn't hear the honorable member. I don't know.
He said he had a similar answer to the same question he asked earlier on, but the answer did not materialize on the ground. How sure are we that this time round, this answer will actually see the light of the day?
Thank you, Mr. Speaker. Mr. Speaker, that is the program of the ministry, and all things being equal, I'm hopeful that it will be implemented as presented. All things being equal.
Well, your answer is built on hope, so you have to hope for the future. That's all what life is. Life is about hope. Honorable members, I go by the rules, so we'll move to the next question. These are constituency specific, and that is what your leader said. So we go by the rule, constituency specific. It's not on that issue. Yes, what?
Yes, Mr. Speaker, thank you very much. I just wanted to seek your indulgence. I have the permission of the Member of Parliament for Nalergu now to ask the question that was filed in his name. You directed earlier that it be published because at the time I did not have his express authority to ask the question on his behalf. I do now, and I was just wondering if you indulge me to file the question, to ask the question on his behalf. Thank you.
Majority Chief Whip.
Speaker, my very good friend is trying to enter the room through the window. You should go through the door. Actually, we have some prior agreement. So we have respect. We have prior agreement that where the questioner is unavailable, the answers will be published. For a very good reason. So, Honorable Sohini, I think the Speaker exercises discretion. I know you are trying to draw attention to that earlier one that was allowed, but the Speaker, you cannot question the Speaker's discretion actually. So, on this occasion, we have noticed you. You are noticeable. So, Speaker, you should just confirm, and then so that we can dispense of business as quickly as possible and call it a day.
Yes, please.
Yeah, Mr. Speaker, maybe the Honorable Majority Whip is not aware that I am a well-trained son of yours. And I wasn't trained to be dishonest. I could initially have risen to deceive the Speaker, most revered Speaker, and the House, that I had the authority of the Member of Parliament to ask the question. But because of my training that I have undergone under the tutelage of the Right Honourable Speaker, I took my time to seek the right mandate from the Honourable Member of Parliament, and now I do have it. And that is why I am rising to seek the indulgence. It's not as if I am not aware of the, standing. Thank you for agreeing to yield to me now. Thank you.
So I will yield to my good friend, except to add that he should just stick to the one follow-up. He should stick to Honorable Sohini. So let's go by the one follow-up. That was agreed priorly. So go ahead. I yield to you.
Honorable members, you can seek guidance in the standing orders on this matter. Decision is taken and we cannot go back to it. So we'll move on. It's in the standing orders. So we move to question number 1660. Stands in the name of the Honourable Member for Amenfi Central, Honourable Peter Yaokwache Aka. The Honourable Member not being available, we will direct that it be published as earlier on agreed upon by the House. We'll go to question number 1709. Stands in the name of the Honourable Member for Kintampo South, Honourable Alexander Jan. Honourable Member, you may ask your question now. Yes. Honourable Member is not available, and so the same directive for the question and answer to be published. We move to question number 1717. Stands in the name of the Honourable Member for Pandai, Honourable Daniel Nsala Wapal.
Thank you, Right Honourable Speaker. I write to ask the Minister for Road and Highway. Plans the Minister has to construct bridges to the following to facilitate movement from the communities. The following communities, sorry. Pana Dubun, Nanjuro, Kachika. Thank you.
Yes, Honourable Minister.
Thank you, Mr. Speaker. Mr. Speaker, the Pandai, Dubong, and Nanjiru, Kachinke are among communities in the Pandai district of the northern region, which have major channels and streams separating communities. Most of these communities are difficult to reach during rainy season. There are currently no program on the bridge construction in the area. The water crossing points within the communities have been captured as part of Department of Feeder Roads Bridge database and will be considered in future bridge programs. Thank you, Mr. Speaker.
Thank you, Right Honorable Speaker. In the answer provided, the Minister said there are no current programs to construct bridges in these communities. But he also agreed with me that during the rainy season, it is very difficult to use these roads. And so, Minister, I want to plead, if I know these communities are also farming communities, they engage mainly in agricultural production. And I want to plead with you, if there will be any interim measures that can be put in place, now that we are entering rainy season, it will be very difficult for this farmer to transport their farm produce from the community to the marketplaces. So if you can, there will be any interim measures. Other than that, it will be very difficult for them to transport. Very soon in July, we'll be harvesting the new yams. And so this yam will be left rotten. So if there will be any measure to help, I will help. Thank you.
Thank you, Mr. Speaker. Mr. Speaker, I share the concerns of my colleague member that these are very difficult areas during rainy season. And as I did indicate, we have plans to undertake bridge program there. He is talking about remedial interim measures. Mr. Speaker, I want to, after here, engage my colleague so that you can find possible means of providing these remedial measures and temporary measures so that they can bring some relief to the people in the area. Thank you.
Honorable members, we now move to question number 1723. Stands in the name of the member for Afram Plains South, Honorable Joseph Apia Boateng. You may ask your question now.
Thank you, Mr. Speaker. To ask the Minister for Roads and Highways when construction of a bridge over Afram Plains South will be commenced.
Yes, Minister.
Thank you, Mr. Speaker. Mr. Speaker, the Volta Lake is the longest man-made lake in the world. The Afram Plains on the eastern side of the lake is referred to as the breadbasket of Ghana. Accessibility to the Afram Plains across Afram River is by the usage of pontoon. Provision of Afram Bridge will improve accessibility between Adalso and Echiaman From. Mr. Speaker, Parliament approved an amount of 350 million euros for the construction of the bridge over the Afram River and its related ancillary roads in February 2022. However, the financing agreement had not been signed due to government's debt restructuring program. The government will continue to find avenues for the construction of this very important bridge across the Volta Lake. Thank you.
Yes, any supplementary?
Yes, Mr. Speaker. Mr. Speaker, I want to ask the minister, once that Finance Minister said the restructuring program is over. Now that it's over, when are you moving to the site?
Thank you, Mr. Speaker. In fact, the financing agreement has not been signed, and I'm not aware of any official statement from the Finance Minister on the debt restructuring. But what I know is that government is committed to the construction of the bridge over the Volta Lake, and we will continue to find various avenues to make sure that that is happening. Thank you.
Honourable Member, we'll go by the rule of one supplementary question. So we'll go to question number 1726. Question number 1726 stands on the name of the Honourable Member for Ilo Krobo, Honourable Dr. Albert Tete Nyakote. Honourable Member, you may once again now ask your question.
Mr. Speaker, I rise to ask the Minister for Roads and Highways when the construction of the Otopolu Bridge in the Ilo-Krobo constituency will be completed.
Yes, Minister.
Thank you, Mr. Speaker. Mr. Speaker, the Otopolu Bridge links Otopolu Township to Krobo Udumase and beyond. It is located in the Yellow Krobo municipality in the eastern region. The Otopolu Bridge is one of the 50 being constructed by the government of Ghana through the 47 million euro facility agreed between the government of Ghana and the Czech Republic. Work started on the 3rd of March 2021 for completion date by the 3rd March 2022. Works executed to date include one abutment and central pier completed on the Otopolo side of the bridge. Excavation works for foundation for abutment also ongoing, and progress physical completion rate is currently at 40%. The contractor, Mrs. Nice AS, has suspended works due to the debt restructuring program. Efforts are being made to bring back the contractor to site to complete the works. Thank you.
Any supplementary?
Mr. Speaker, the Otopolu Bridge was constructed in the 1920s, and the bridge is currently in a very bad shape. In the minister's response, he said he's making efforts to bring back the contractor to the site to complete the works. When do you anticipate to bring the contractor to the site, Honourable Minister?
Thank you, Mr. Speaker. Mr. Speaker, I will not be able to give the exact dates, but I have been, since assuming office, I've been working very hard on this, including taking a trip to the Czech Republic to negotiate for disbursements that contractors can work. So we are working very hard on that. Thank you.
Honourable members, we move to the next question. That is the last for the day. Question number 2206 stands in the name of the Honourable Member for Lejokuku, Honourable Benjamin Nate Aiku. Lejokuku.
Thank you, Mr. Speaker.
Honourable members, since the Honourable Member is not around, I direct that.
Yes, Speaker, I'm here, sir.
Oh,
I'm here.
sorry.
Thank you, Mr. Speaker. I rise to ask the Minister for Roads and Highways steps the ministry is taking to construct inner road networks in the following communities in Lodikuku. 1, Camp 2, 2, Demo, 3, Opogono, 4, Aglizan, and 5, Sea Lady.
Yes, Honorable Minister.
Thank you, Mr. Speaker. Mr. Speaker, Lejokuku is a municipality within the Greater Accra region, with Teshi as its capital town. Regarding Camp 2 and Demo, the government of Ghana, through its implementing agency, Department of Urban Roads, is executing rehabilitation of Alloway and Sixth Avenue extension and Demo roads, which is 4.3 kilometers road project. The project comprises the construction of drainage and roadworks on the Demo road and the Camp 2 road, and aims to improve connectivity for commuters between Teshi Bush Road and the Teshi Link Road. The contractor commenced work in September 2020. However, he vacated site in December 2020, and all attempts to get the contractor back to site have proven futile. Current works progress stands at 10%. The department has recommended the project to the Ministry of Roads and Highways for termination. On Okwegono, the Ministry of Roads and Highways through the Department of Urban Roads is executing the rehabilitation of boundary roads, Okwegono, 9.8 kilometers, categorized as Lot 2. The project is ongoing within the Okwegono electoral area is intended to improve accessibility for the residents of Nungwa, Teshi, and Okwegono localities. The project is currently at 38.5% physical completion, and the contractor is currently on site. On Aglezan, the ministry, through Urban Roads Department, is executing the rehabilitation of Power Surveyors Drive, Mayfair Road, and Christ Impact Church area at Christ Impact Church area roads at Chado, which is 5.5 kilometers road. The project comprises the construction of drainage and roadworks on the Penny Road and Obia de Ben Mayfair Road, and some local link roads in the Ablazan electoral area of the Lejokuku municipality. The focus of works is to improve connectivity within the enclave located between Teshi Link Road, New Sprinters Road, and the Bema Camp Road. Currently, progress stands at 70%. The contractor is on site. Regarding Sea Lady, the Department of Urban Roads is executing the partial reconstruction of selected roads in those areas. The project comprises the construction of drainage and roadworks in the Sea Lady, Alloway, Malek, and Baptist areas of Lejokuku municipality. The focus of work is to improve connectivity within the beneficiary communities. The project is at 12% physical completion. Works have stalled currently, and the contractor has vacated site. Efforts to get the contractor back on site to complete the outstanding works have proven futile. So the necessary recommendation for termination will be undertaken. The outstanding works will be repackaged for future program under the 2025 budget. Thank you, Mr. Speaker.
Any supplementary question?
Yes, Mr. Speaker. The Speaker, from the Minister's answer, it says, since 2020, the connector has abandoned site and all effort to get him back has put futile. In the entry, the roads are very, very, very bad. I want to find out from the Minister the measures his ministry is taking to make those bad roads motorable, to give a little relief for the residents and motorists. Thank you, Mr. Speaker.
Well, honorable members, with this appeal to the minister, it's not a question. I think we will end the question time now and move to any other item as guided by the leaders. Which other item are we taking?
Speaker, at the commencement of public business, may we take item 9S, S for sugar, on page 11 of today's order paper.
Honorable members, let me thank the minister for attending upon the House to answer the questions. We are most grateful. We'll now move on to public business. At the commencement of public business, item
Speaker, with item 9S on page
item
11.
9S.
Yes.
At page 11, by the chairman of the committee, report of the Committee on Education on the National Service Authority Bill 2024. Chairman of the committee.
Report of the Committee on Education on the National Service Authority Bill 2024.
Honorable members, the report is laid accordingly and is for distribution to all members of Parliament. Yes, please.
Speaker, on same page 9T. T, on same page.
T. By the chairman of the committee, the report on Committee on Roads and Transport on the Ghana Civil Aviation Bill 2024.
Report of the Committee on Roads and Transport on the Ghana Civil Aviation Bill 2024.
Honorable members, the report is presented accordingly and is for distribution to all members of Parliament. Yes.
Speaker, we should be moving on to order paper addendum and take the Environmental Protection Bill 2023 at the consideration stage. Speaker, the amendment should be led by the chair, but we have some understanding that the ranking will lead the amendment for today. So we move on to order paper addendum, Speaker.
Honorable members, do you have copies of the order paper addendum? Please, copies of the order paper addendum. Make it available to members. We are now at the stage of the Environmental Protection Bill 2023. Yes, Minority Chief Whip.
Yeah, Mr. Speaker. Yes, I agree. At conclave, we agreed to do this, but we would be happy if you take us to only clause 44 for today, which is on page 3. Page 3, up to clause 44 only. Yes.
Thank you, Mr. Speaker.
Yes.
Speaker, I rise to speak in support of the application made by my good friend, particularly in the face of the fact that we are having an ongoing winnowing together with the chief whip and the chair and the ranking. So I think that's where we've gotten to. So it makes sense that we end at where he suggested, and then we'll continue with our winnowing and proceed from there.
So the proposal is for us to end at clause 44. Yes.
Thank you, Mr. Speaker. Mr. Speaker, yes, clause 35. Clause 35.
Okay, let me put the question first. Honorable members, clause 35. Yes.
Clause 35, Mr. Speaker. Amen. Yes,
Yes, go on.
I thank you. Mr. Speaker, clause 35, amendment proposed. Add the following new sub-clauses. Where a person fails to pay an administrative penalty imposed under Section 4, the authority may recover the administrative penalty as a civil debt. And the second clause, a person who fails to comply with an enforcement notice imposed under this section commits an offense and is liable to summary conviction to a fine of not more than 15,000 penalty units, or to a term of imprisonment of not less than 5 years and not more than 10 years, or both, or to both. Sorry, I so move, Mr. Speaker.
Yes.
Mr. Speaker, this is not in line with our practice. Our practice is that punishment will normally set the minimum and the maximum. So in case of this, there is a need for a minimum fine and the minimum sentence. If you want the minimum fine to be 15,000 penalty unit, if you want the maximum to be 15,000 penalty unit, and then a term of imprisonment of so, Mr. Speaker, to help, a person who fails to comply with an enforcement notice imposed under this section commits an offense and is liable on summary conviction to a fine of not
less than.
Yeah, not less than maybe 5,000 penalty units and not more than 15,000 penalty units, or a term of imprisonment of not less than 5 years and not more than 10 years, or to both. Mr. Speaker, the drafting section will help us so that we can correspondingly fix the minimum fine to coincide with the minimum jail term, and then the maximum to coincide with the maximum years of imprisonment.
Yes, there is an act on it, so the act will guide the draft person to be able to get us the minimum fine be inserted. So I will direct that the draft person should accordingly assist the House in this direction. So I put the question. Those in favor of the proposed amendment by the addition of the following new clauses which have just been read, say aye. Those against, say no. Honorable members, the ayes have it. I will now proceed to put the question on the whole of clause 35. And the question is that clause 35 stands part of the bill. Those in favor say aye. Those against say no. The ayes have it. Honorable members, clause 35 is ordered to stand part of the bill. Clause 36.
Powers of Minister.
Yes, honorable member.
Mr. Speaker, clause 36, amendment proposed, subclause 1, line 2, after I, insert 2. Insert 2. And the rendition is. Insert or 2? No, insert. Insert or 2, sorry. Insert or 2. Yes. I so move, the Speaker.
Honorable members, those in favor of the proposed amendment, say aye. Those against, say no. The ayes have it. The amendment is carried. We still have further amendments to clause 36. Yes.
Clause 36, aye. Subclause 2, line 3, delete force necessary and insert reasonable force. Insert reasonable force, Mr. Speaker. I so move.
I don't know whether I can ask the lawyer to give that defense.
Honorable members, those in favor of the proposed amendment say aye. Those against say no. Honorable members, the ayes have it. I will now put the question on the whole of clause 36. And the question is that clause 36 as amended stands part of the bill. Those in favor say aye. Those against say no. The ayes have it. Honorable members, clause 36 as amended is ordered to stand part of the bill. Clause 39. Have you done 38? 37.
Request for information.
Clause 38.
Establishment of the National Environment Fund.
The question is, clause 37 and 38 stand part of the bill. Those in favor say aye. Those against say no. The ayes have it. Clauses 37 and 38 are ordered to stand part of the bill. Clause 39.
Object of the National Environment Fund.
Yes, Chairman of Committee.
Mr. Speaker, clause 39, amendment proposed. Opening phrase, line 1, delete regulate and insert support the regulation of.
Honorable members, yes.
Speaker, I support the amendment proposed by the ranking member, but to further propose an amendment that in line 2, we delete the possessive pronoun, it. So, Mr. Speaker, the new rendition will be the object of the National Environment Fund is to support the regulation of the environment in all forms with the views to ensure then ABC will come. Then we delete the possessive pronoun.
Yes. What do you say to that?
I think that is right.
That's correct.
Yes, sir.
Honorable members, I put the question now. 2 amendments have been made. Those in favor of the amendments say aye. Those against say no. The ayes have it. The amendments are carried. I put a question now of clause 39. And the question is that clause 39 as amended stands part of the bill. Those in favor say aye. Those against say no. The ayes have it. Honorable members, clause 39 as amended is ordered to stand part of the bill. Clause 40.
Sources of money for the National Environment Fund.
Yes, Chairman.
Yeah, clause 40. During the discussion, we said we should step it down. Yeah, because we're not too sure about the Customs Amendment Act. So, Mr. Speaker, clause 40, which that we stand down there. No, we're supposed to delete, but yeah, we are standing for now for consultation to continue here. So, Mr. Speaker, we'll stand down clause 40 for now.
Honorable members, yes.
At the winnowing, the agency representatives were there. When they asked us to delete this, because we are talking about the sources of funding, it appears they only said they wanted to delete it because they don't know whether they have clearance or whether that fund would allow them to do that. But I said once the AG helps you prepare this, it means that it has been discussed. If it's the percentage, that we can work on that. So they should rather go back to do consultation. So we agree with him. We step it down. We don't actually do anything about it. But when they come back to us, which is tomorrow, they are coming back tomorrow, we can take a decision on that. So I agree with him. We step it down. We don't take a decision on that particular clause at the moment.
Honorable members, clause 40 is 2 down until the issue is clarified. Clause 41.
Bank accounts of the National Environment Fund.
Clause 42.
The National Environment Fund.
Honorable members, there being no amendment proposed to clauses 41 and 42, I put the question that clauses 41 and 42 stand part of the bill. Those in favor say aye. Those against say no. The ayes have it. Honorable members, clauses 41 and 42 are ordered to stand part of the bill. Clause 43.
Regulations.
Yes.
The Speaker, clause 43, amendment proposed, paragraph B, line 1, after importation, insert transportation. Transportation. I so move, the Speaker.
Honorable members, those in favor of the proposed amendment say aye.
Aye.
Those against say no. The ayes have it. The amendment is carried. We have further amendments to clause 43.
Yes, the Speaker. The Speaker, via aye. Clause 43, add the following new paragraph after paragraph T. regulate the removal of urban tree cover. Regulate the removal of urban tree cover. I so move, Mr. Speaker.
Honorable members, those in favor of the proposed amendment say aye. Those against say no. The ayes have it. The amendment is carried. We have further amendments. Yes, please.
Add the following new paragraph after you. Establish a reclamation financial security scheme for the mining industry. I so move, Mr. Speaker.
Honourable members, those in favor of the proposed amendment say aye. Aye. Those against say no. Honourable members, the ayes have it. The amendment is carried. I put the question on the, sorry? Yes, Honourable member.
Yeah, thank you, Speaker. Speaker, I, under Regulation 40, Clause 43, Speaker, I noticed in recent times that
Regulation
43, Clause 43, under Clause 43 under Regulations.
Yes, Clause 43, yes.
Yeah, Speaker, I noticed in recent times that the power of the minister to come up with regulations are limited to within 12 months after coming into force of the Act. But this provision has omitted that. I want to find out whether it's in order to leave this one open, since others have been saying 12 months within which the minister is to come out with the regulations.
Oh, is that the rule now? Yes.
It's not clear.
It's not too clear what?
What he says is that in earlier regulations, there is a clause directly stating that the regulations must come out within 12 months. Am I right? But it's absent here. That's why it's raising that issue. I'm not aware of that, but I don't know which law you passed giving that limitation. Yes, Honorable Bernard Ahiefo.
Mr. Speaker, in fact, this has been debated on the floor as to whether we should time the ministers the period within which they are supposed to make the regulation. Because some of the ministers, after giving them the power, the regulation is for to give effect to the implementation of the law, but they go to sit down and they don't come with the regulation. So they should be made to make the regulation within a year after coming into force of the regulation. But the other argument is to the effect that what happened to the minister in the event the minister failed to comply with the 12-month mandate. So what then will be the force and effect of stating a period within which the regulation will have to be made, and then the minister will default in making the regulation. So in some of our laws, we stated that the minister should make the regulation within 12 months from the date of coming into force of the law. And Mr. Speaker, they will always appear before the Subsidiary Legislation Committee to say or to justify why they have not been able to bring the regulation within the 12 years period. So, Mr. Speaker, I am not too fixated on stating the period within which the regulation is supposed to be made, in view of the fact that mostly they do not comply with the time frame given by the law.
Yes.
Speaker, earlier on, it was timeless. The regulations that the ministers were required to submit to the House. They were not time-bound. And it explains why, after the passage of some bills, more than 4 or 5 years, they were not coming forth with the regulations. And so it was decided that we should impose some time frame, which is why we came to agree on the 12-month rule. So, Mr. Speaker, at least let it be stated, just for the avoidance of doubt, that they should comply within 12 months. If they don't, then we will have the energy to force them to bring the regulations. Other than that, if it is not time-bound, more or less, there's no urgency imposed on them by any law to submit the regulations. So I'll go along with the request by the colleague who raised it, and I think we need to instate it in the section.
Yes.
No, you let the minister speak.
Oh, please. Okay. Mr. Speaker, I'm inclined to agree with the former leader. You see, the sins of the past should not, should not disable us from doing something rather new. I remember even in the health insurance, even the main law, it is stated that it's compulsory. But I wonder how many Ghanaians comply. And there is no sanction. And I remember those days, then Papa Usankuma, who was then the Attorney General, said, if you cannot enforce it. But there are certain things, because environmental issues are very, very important these days. I believe that the time limit should even be there so that any minister, at least if he's so minded, will be then compelled to take action. Besides which, it is the regulations which are going to give teeth to this law. So I believe that I believe that we should put it there. But I don't know about sanctions, though.
Mr. Speaker, 41 clause 43 reads, the minister may, on the advice of the board, by legislative instruments, make regulation for then the listed items. The word is may. So if you give timeline, what happens if the minister decided forever there shouldn't be a regulation? Then if you want to make it mandatory, then it should be the minister shall. Once it is may, it's permissive. So if there is no need, the minister will not. But if there is necessity, then we need to do something about the permissive word may used in the regulation, or used in the law.
My lawyer is overstretching this. If you look at the items for which we are supposed to make the regulation, for instance, Mr. Speaker, we are supposed to make regulation to protect the protection of any particular species of fauna and flora, to the improvement of quality of the environment, matters of which permits are required. So entities are supposed to apply for permits. Is it possible for the ministry to, because they don't have schedules that spell out this, they must necessarily put in place certain regulations as and when they are needed to actually give effect to the law. So I don't see the possibility of the minister basically taking this law and implementing it without actually bringing regulations. I agree with him. They may not be able to bring regulations covering everything here at the same time. But that is why they say may. Maybe if it's not necessary or they are not implementing a part of it, there may not be any need to bring a regulation at the time. But I agree that the way it's captured should be the way it should be. That as and when they need a particular regulation to give effect to any part of this, then they can do that, Mr. Speaker. So we shouldn't do it sharp. because they may not need a regulation on everything at the same time.
Mr. Speaker, indeed, I don't believe that it's every act which calls for a regulation. Some of the acts are so explanatory and they are so short. I've seen acts which are composed of only about 3 provisions. So that is why May should stand. Thank you.
Mr. Speaker, I think the drafting language has always been may and not shall. It's always been may. And the Honorable Ayafu, who is a permanent representative on the Winnowing Committee, knows this. He knows this. As to where to insert the 12 months, it may just come before the legislative instrument. The minister may, on the advice of the board, within 12 months, by legislative instrument, make regulations for. Then it follows.
I was considering whether it should always be 12 months. But when you look at the items involved, particularly this one, it's most likely the minister will use more than 12 months because of for example, talking about standards and codes of practice relating to protection, development, and rehabilitation of the environment. That crafted and for the minister to consider and then send to the board for advice is likely to take more than 12 months. And so what is the purpose?
Mr. Speaker, our colleague initially was saying that we should
use shall.
We should use shall.
Yes.
If we use shall, that would be too much restrictive. But he may do so within 12 months. That is a bit permissive and allows him some room to operate.
Yes.
Speaker, Parliament will not make law in vain. The law must be complied with. Therefore, if we are saying the minister must within 12 months make the regulation, let's say so that he will be time bound to make the law within the specified period. Mr. Speaker, I believe strongly once we are setting down the procedure by which the legislative instrument is supposed to be made, particularly within the time frame of 12 months, if we say so, then it means that the minister must comply with the law. Other than that, the law that we are making will be in vain. If we can state 12 months and allow the minister to make it within 12 months or not to make it within 12 months, then it's better we don't impose any time limitation.
Yes.
Mr. Speaker, I'm really struggling to understand why my colleague is litigating this. It's standard draft language. Mr. Speaker, let him go to section 1.2 Section 1.2. And he's saying that Parliament, when we make laws, we should be compelling. 1.2 says that the authority may, for the performance of the functions of the authority, acquire and hold property. They may do that. It doesn't mean that they will not do that. It doesn't mean that they will not do that. So, Mr. Speaker, I sometimes tell my colleague that he sometimes becomes unnecessarily an eternal litigant. Otherwise, I don't see why you are litigating this matter.
Mr. Speaker, leader is now giving me his title. He is rather the eternal litigant, but he's not giving me the title. Mr. Speaker, clause 1.2 is correct. The authority may, for the performance of the functions of the authority, acquire and hold property, dispose of property, and enter into a contract or any other related transaction. It is not compulsory, and there is no time limit for the authority to acquire property. As and when the authority decided to acquire property, the authority may do so. So the clause 1.2 is correct. The use of it is correct. The authority is not under obligation, and the authority is not time-bound to acquire property or hold property. But the regulation that we are saying they should make within 12 months, it means that the minister is time-bound to make the regulation. Because you are supposed to do that within 12 months. So my question is, what happened if the minister failed to do it within 12 months? Is Parliament making the law in vain?
Mr. Speaker, let my colleague take his time to read this. The minister makes regulations. He makes regulations for achieving effect of the law that we're making. Now, these regulations could be in the form of a legislative instrument. It could be in the form of a legislative instrument. Don't forget that some regulations could be internal, which may not mean a resort to legislative instruments. So the minister may make regulations for this. And the making of the regulations could be in the form of a legislative instrument. So you may opt to come by a legislative instrument to do the regulations. But there are some regulations that may not require a legislative instrument. They could be administrative. Mr. Speaker, that is the import of the preambular. And I believe we have been doing this all the time. My colleague, let's move on and make progress.
In paper and heart, parliamentary debates will be a guide to interpretation. So, Mr. Speaker, I will rest my case.
I have a challenge because of on the advice of the board. On the advice of the board. The minister may, on the advice of the board, by legislative instrument, within 12 months, make regulations for, on the advice of the board. You are delegating authority to the minister, and you are subjecting that delegated authority to a board. Yes, Parliament is delegating an authority to the minister to make regulations, and you are subjecting it on the advice of the board. Now, if the board doesn't advise the minister, what happens? So the minister cannot make the regulation. That's the challenge I have. Yes?
Mr. Speaker, I think the board has been drawn into this because of the technicality involved in the functions of the authority. The driving vehicle.
Yes, I've gone through that.
Yes, the driving
Yes.
vehicle of which is the board. So if you have a minister who is not a technical person, who superintends over such necessarily, he may want to seek the advice of the authority before coming in with the regulations. But the minister holds final responsibility for the instrument that will come, or the regulations that will come to the House. But of course, because he may not be a technical person, he may have to seek the technical advice from the authority before coming here. I guess that's the import of it.
Yes, I know, but I recollect the judicial interpretation on this, on the advice, in consultation with the advice.
It's the same thing. The same thing.
It's not the same.
He ultimately.
There have been some pronouncements, judicial pronouncements on this. That's what I'm not sure. Yes.
What we've been saying, instead of on the advice, is on the recommendation. That's the word we've been using. So if you take the National Rules Authority Bill under consideration, clause 57, it reads the minister may, on the recommendation of the board, by legislative instrument, make recommendation. So we use the word recommendation instead of on the advice based on the judicial interpretation.
Yes, Majority Leader.
Mr. Speaker, first on the leg of an advice from the board, a minister of state always acts on advice in the performance of his ministerial duties. You have technocrats who advise you, who you engage to arrive at a decision in one way or decision of the other. Of course, the final decision. In the same vein, a recommendation from any committee set up by you may not be binding on your final decision, but it's a guide. For me, we don't need to legislate by using such language. We can simply say the minister may, by regulation, do this, and then you are good to go. So the minister, by legislative instrument, make regulations for. Yes. Then we avoid all of that, because there is that presumption that you would not be indiscretion in terms of just getting up and coming out with the regulation. The regulation itself, before even enacted, goes through a process where you get, a committee to look at it, and then it goes to the AG for input, and then it comes back to you. Although it bears your final signature, but there's a whole process that the law will go through. So it's superfluous to state that on the advice or upon recommendation. Let's simply say that the minister, by legislative instrument, make regulations for, and then we avoid all this banter here and there. Well, Mr. Speaker, for the time being, I see a banter. The respected former leader and his son, Honorable Ahiafo, they normally agree, but on this occasion, they're having a prolonged disagreement. So, very well. Oh, he has agreed. But, Mr. Speaker, I think it becomes neater and to proceed. I know that in previous legislations, it said the minister by an ally make regulations without having to say upon advice. In any event, the judicial pronouncement on advice is to the effect that it's not binding. In the GBA Richard Sky matter against judicial service, Judicial Council and the Electoral Commission. My Lord Atuguba was very clear. Because the argument of GBA was that Judicial Council had advised the President on a matter regarding appointment to the Supreme Court. And the President was bound by the advice because the Constitution makes provision for advice as part of the imperative for the appointment. So there was no absolute discretion on the part of the President. But the judiciary said no. The Supreme Court, speaking through my Lord Atuguba, said no. It's an advice. It's open. But there is no binding effect. You know, the President, in exercise of discretion, could pick from any. So we have to also be careful what value we place on the phrase on the advice. I thank you, sir.
That has always been my position. The advice is advice. It's not binding. It's an advice. But we have to subject it to such delays, particularly when you are giving timelines. That is the issue. You give a timeline, but you are subjecting his performance of that obligation to another advice. And so he's compelled to go through the process. That is the thing. Once you put it there, he's compelled to refer it to the board, then await their advice or recommendation. But you are giving the minister to do it within 12 months. And that's why I thought that phrase on the advice of the board should not be part of the clause. That's my respectful view. But I'll put the question.
Respectfully, sir. Mr. Speaker, I think I may want to proceed to make an application for an amendment.
I saw the mover of the motion on his feet. Maybe he has something to say before I come to your. Yes, please.
Thank you, Mr. Speaker. Mr. Speaker, I think that, as you said earlier on, when you look at the scope of the regulation, it will be very difficult to limit it to a year, because some of them, they have to be founded on some research, and such, issues are sometimes very dynamic. So as and when issues arise, you may have to come up with some regulation or administrative advice. So, Mr. Speaker, and then with the board, when you look at the organogram, with the board, we have the technical wing of the board that will necessarily have to advise. So, yes, so we would have to, leave this at this stage, Mr. Speaker.
You are proposing that we don't limit it to the 12 months. We just leave it as it is. Let me listen to the minister first.
Mr. Speaker, I believe that your position and that of the leader is correct, because any minister, if you working on these matters, it presupposes that you go through a system where your technical people will advise you, and then the board will also have to. In fact, that is their job. But if you stay, because you are ultimately responsible, and you can actually discard advice, sometimes you will have to. You discard advice, and you are ultimately responsible. I think your rendition is the perfect one.
Yes.
Mr. Speaker, my colleague is mixing two things in a pot. There are two things before us. One is the 12-month rule, and the second is whether or not the minister should seek the advice of the technical people in this matter. Mr. Speaker,
I'm sorry.
And Mr. Speaker, if we should discard the 12 months rule because of the issues involved, I would say that I have no fixation on that, even though that is what we've been doing recently. Now, with respect to the other one, that you must seek the advice of the board, I think it's very relevant because it's a technical matter. And even though ministers are required, because they are giving some discretionary power in this, they are required to exercise the discretionary power not arbitrarily, in accord with Article 29, and not capriciously or be biased in the exercise of the discretionary power. I think, as far as these technical matters are concerned, they may have to seek the advice of the technical group that they themselves superintend. If they decide after the advice, because of course a minister may also have some backroom advisors, and after balancing the advice, the piece of advice, he may elect to choose one. He's not bound by the advice that is perfect, which is what the leader has alluded to. It doesn't mean that he must necessarily conform. That is taken as a given. Because the language is advised or maybe in consultation with, or as you said, on the recommendation of. There are some instances where the Constitution would necessarily require you to conform. As for instance, Mr. Speaker, Article 197, when the Public Services Commission is required to make regulations, subject to the approval of the President. In that regard, they cannot, they must act on the recommendation of the President. The President must approve of it before it comes. The regulations will come. That is a different kettle of fish. But having said that, Mr. Speaker, I think we have spoken about it. We have discussed this for a long enough period. We can take a position. Maybe, as the Honorable Taylor is saying, giving the nature of the referrals, some of them may take more than 1 year. So perhaps we can relax that rule with respect to this bill. But that we must act on the advice of the technical group. Let us maintain that. But thank you.
Yes, please.
Mr. Speaker. My respected senior knows that I ordinarily would not debate you on matters like this. But respectfully, let me put across my own modest views. Mr. Speaker, the entirety of his argument are correct, right, and associate with it. But I disagree in terms of context in respect of the matter before us. Putting it generally, he is right. But the context of this language makes it superfluous to have the advice. Mr. Speaker, let's be very practical. The argument here is that the minister may, on the advice of the board, which board is the very body that he superintends. But Mr. Speaker, what of if there is a government policy which will require an enactment of a subsidiary law to operationalize this parent law, and the board perhaps is not minded to express a view, but the minister would have a technical committee that may be taking advice, information from cabinet, and it's of such importance to government that there must be an enactment. If we say that on the advice of the board of EPA, and the board is not giving any such advice, or does that mean that the minister's hands are thereby tied, so he cannot? Mr. Speaker, what is the rationale behind subsidiary law? To come up with an operationalization of the main law and perhaps address certain, pertinent issues which would not be outside of the intendment of the main law. So nothing should impede or, as it were, Mr. Speaker, hinder the process of achieving that. A minister of state should have that discretion, that space, to be guided by policy to act. So if the board is not ready, does that mean that the LI will not be in place? And that is where my disagreement fundamentally arises from, in terms of context, from the former leader. So, Mr. Speaker, let us take away the upon advice from the board. In any event, he said we should take a decision. So, with all these arguments trying to persuade him on my side, I think I've yielded to him, Mr. Speaker. I have yielded to him severally, and he knows that. So this is one occasion that I am humbly praying that he should yield, for a simple reason that the open advice is merely superfluous. It will not harm his argument. Hansard has recorded him, Mr. Speaker. Hansard has recorded him, and any jurist would rely on Hansard to guide an interpretation. So he shouldn't be bothered at all. So, Mr. Speaker, having said so, I shall pray that on the advice of the board be deleted. The new rendition should read: the minister may, by legislative instrument, make regulations for, and then the others follow. I have nothing to add on the issue of the 1 year. That's an argument I entirely would stay away from. Mine is what I have so expressed. Mr. Speaker, you may now get the plenary to take a decision, having heard both of us. I thank you, sir.
Yes. With the greatest
I'll
respect,
come to him.
with the
Yes.
greatest respect, my colleague, who just spoke, the majority leader, I disagree with him. The Speaker, there cannot be any subsidiary legislation the policy and opinions of which would differ from the substantive legislation. There cannot be. It's totally wrong. That's what we said. Oh. You said.
That's not my argument. It's never been my argument. I don't want Mr. Speaker, it's never been my argument. I don't want Hansard for a moment to hold this
Let
against
there
me.
be order.
Mr. Speaker, there is order.
He is on his feet.
Mr. Speaker, that is so.
Resume your seat.
Mr. Speaker, very well, I will.
Yes, please.
Mr. Speaker, I'm happy my junior brother is sprinting away from what he just said. I'm happy he's sprinting away from what he said. Because that was the justification. He said the minister may come a policy in a subsidiary legislation to give effect to it. It cannot be. It cannot be that a subsidiary legislation would have a policy underpinning which is different from the parent law. It doesn't exist anywhere. And that is why I'm saying to him that he's totally wrong. So let's give the minister, and we expect the ministers to act not arbitrarily. But Mr. Speaker, as I'm saying, the legislations that we have crafted in terms of technical matters, we have always said that the ministers should consult their boards before coming with the legislation. Unless we want to make a departure from that. Otherwise, Mr. Speaker, go for all the pieces of legislation. As I said, I have no fixation on the 1 year thing.
No, the earlier regulations don't usually add on the advice of the board. I can recollect as passing a regulation where we added on the advice of the board. Because see, the operational processes of passing or making regulations, starting from Article 11.7, includes advices from many sources, boards or whatever, technical committees or whatever, experts and all those things. So legislating it will be giving the impression that maybe the ministers don't seek the advice of the boards. Because that is part of the operational processes. To make a regulation, you definitely have to seek advice. So if you are included in the law, then it's conveying something. That I had a problem with it, and that's what generated this whole thing. To eliminate that on the advice of the board. And let's move on. But you have to take the decision, not me. Yes, Minister.
I agree totally with your position. Sometimes let's not conflict general things with what is happening in a technical ministry like MESTI. By all means, before you come here even to do a legislation, you will have taken all the advice from your technical people and your board. Whether you are, you know everything, you cannot operate. So in actual operation, if you are EPA person, you will have to seek advice from your technical people, and then so we don't have to legislate. And I believe that to say that it should be, I'm not talking about environment. EPA can even be hived away from environment. But I'm talking that a technical ministry, that's how it works. You cannot. So let's not, maybe if the social content, then maybe you can say advice. But the technical ministry, it goes without saying that you will have advice. That's why I support your position. Then the number two about the timing. Mr. President, to think that 1 year, Mr. Speaker, to think that 1 year is short and is, with all due respect, very presumptuous.
Did I hear you yield to pressure from your leader?
No.
You are supporting.
No.
You are supporting me.
Yes.
Initially, you referred to me as Mr. President. Then your leader started putting pressure on you. Then you changed to Mr. Speaker.
Oh, I get it now. So Speaker's fine.
Yeah,
who knows what will happen in the future? But Mr. Speaker, on more serious note, I believe that we should not split hairs over this. To legislate on the advice is not good. So let's delete that one. And about even the timing, I believe that 1 year.
Yeah, you timing.
No, I believe that the timing should start. Because, you see, if you take into consideration our electoral cycle of 4 years, if you don't take care, somebody will wait an interminable period. And I believe that all these things were occasioned by these galamsey issues and all that. Because, do you know why this bill is here? It's because there is no central body to control all those activities. And we think that EPA should be in charge. Not that he's going to take over Minerals Commission's job or Forestry Commission. But there must be a referral point to a certain entity who will point it out to them, and it becomes almost obligatory for them to conform to their law. Mr. Speaker, I do not want a minister to have this latitude where he will sit there for 2-3 years without coming with it. This one becomes, if you like, a sort of moral compass to the minister to conform. Within 1 year, if he not come, that is why the omnibus one is like May, so that he can sit on that, so that nobody can say that he should be punished because he does not conform. But the 1 year guideline is very, very important. Thank you very much for your indulgence.
Honorable members, I put the question.
Mr. Speaker, I'll plead with you, just so that you don't get it wrong, because I'm not sure that we, as Dr. Free said, that we should be splitting hairs over this, even though noticeably when he spoke about it. I noticed that he doesn't have hair, and yet he said that we are splitting hairs.
I noticed that you have hair.
Mr. Speaker, I do have some. Mr. Speaker,
I'll put the question on the two positions.
I was just saying that because of what you have been doing, so that it will be consistent. If you can leave it with the draft person to check what you have been doing, and then we move on. Yes.
What is in the road authority bill? On the advice?
Mr. Speaker, we even did a winnowing for the National Roads Authority bill this morning, and the rendition appears to be the same for, in fact, the last three bills we worked on, they appear to be the same. I can understand the argument about, but in fact, we've passed some that are in operation now with the same rendition, and we didn't hear any difficulty from any minister about carrying out.
Then there's a new development.
Yes. In fact, that's what he said initially, that in the last 5 years, what we have been doing is what is in this. You are right. Maybe be proud to that. Maybe we were doing something else, but since then, this is what we've been doing.
Honorable members, let me put the question. You have to take the decision. So, and the question is that clause 43, clause 43, no. Was the clause 43 we have here is add the following new paragraph. That's what we have on the order paper. But this is a different proposal. I think it's coming from the floor. For us to add within 12 months. Within 12 months. And that is clause 43. Yes?
Did we, are we agreeing to adding the timelines?
No, within 12 months is what is on the floor.
So let's say no to the timelines, please.
He proposed it.
Yeah.
Yes. And the support of the former majority leader is very loud.
Yeah.
And
my position.
You did not oppose it.
I oppose it.
My attention is drawn to the fact that that is now the new rendition. So I want to put the question on that. On the advice of, our attention has been drawn to a number of recent regulations where it's been carried through by the same house. So I have this, and that's why I said maybe it's a recent development, and I'm told within the past 5 years.
Mr. Speaker, let's clear the issue of the within the 12 months issue. Then, but as for the amendment, it would have to be done. We cannot enact on the advice of the board. That I feel strongly about that, and I think we have to take it out. Amendment, have a new rendition. The minister may, by legislative instrument, make regulations for. Then we continue with the rest. So we leave that one out.
Honorable members, in the circumstances of this case, I will defer the question and then refer to the draft person to look at and advise us accordingly. So we go to 44.
Interpretation.
Yes, yes. Just a minute.
Mr. Speaker, when I entered, the Honorable Taylor was moving amendment on behalf of the chairman. It had to do with what a 3T, and said it should add the following new paragraph after T: regulate the removal of urban tree cover. I think the amendment was moved by the Honorable Taylor, and it was carried. You moved the amendment and it was carried. Yes. Yes. The Speaker, I was just looking at the O. The minister may make regulations for, O says, urban and peri-urban trees. Now, you are saying regulate the removal of urban tree cover. Does the O there not cover the new paragraph that you are introducing, making regulations for urban and peri-urban trees? And the regulations would, I believe, include the removal of the urban tree cover. But if indeed it must stay the way it's being proposed, then you must necessarily also then add the peri-urban trees. Because you are talking about urban and peri-urban trees. 43. I'm saying 43O in the bill. The bill is urban and peri-urban trees. Is N. In my is O. Oh, this is.
Yours a different version that you have.
I see. It's N. Oh, okay. This week I'm told that in the revised standard version is N. So the N is urban and peri-urban trees, making regulation for the two of them. And I thought that in that regard, it covers the tree cover. So you come and you are introducing another regulation after T to regulate the removal of urban tree cover. And I'm saying that that is subsumed under N, which is making regulations for urban and peri-urban trees. But if you feel strongly, because I wasn't there when you went through the winnowing, if you feel strongly about the tree cover, then you should also add peri-urban. I think that is the import of what I'm saying.
Yes.
Yeah, I think that what former leader is saying may be right. Because if you are having regulation for urban and peri-urban, no.
He doesn't have the right.
You don't have the.
It's there already. It's already urban and peri-urban.
We have.
In your case, it's N.
No, it's N. Yes. What we are adding is to regulate the removal of urban tree cover. Yes. So if okay, then maybe we might have to add something to N so that it will take care of it. Yes. Yeah. So we can add. Yeah.
My case is this one.
They should argue that you probably need to drop your amendment and rather go to N and say the removal of urban and peri-urban trees, because in the bill it just says urban and peri-urban trees, regulation on urban and peri-urban trees. What do you want to do with it? But the new rendition is talking about removal. So instead of having a new clause, we go back and amend clause N and say removal. We don't have to.
Speaker, I was thinking that the suggestion or the proposal from the committee, which Honorable Taylor has rendered, I thought it's subsumed under N, that is regulating urban and peri-urban trees. It will include the removal of the trees. It will include even cutting the branches and so on and so forth. Yes, that's what, it's all inclusive there.
Yeah.
And that is why I'm saying that I don't, not knowing what happened there at the winnowing, if they want to introduce that as a separate provision, then you should include peri-urban tree cover. But I think that it's assumed under N.
And delete what you have. Yeah.
Yes, please.
Mr. Speaker, thank you. I mean, we'll take a cue from what is said. We'll consider that. Because the regulation takes care of the management of urban and peri-urban, which includes removal and everything.
Well, I deferred consideration of that clause 43, so
okay.
You can go back
look at
to
that.
it.
Okay, thank you very much.
Yes. We are now on clause 44.
Interpretation.
Yes, please.
Yeah, Mr. Speaker. For interpretation. Interpretation of environmental protection levies, line 2. Delete including advanced eco levy. Delete including advanced eco levy. I so move.
Honorable members, the motion is very clear. Those in favor say aye. Those against say no. The ayes have it. The motion is carried. Yes, we have further amendments.
44. Amendment proposed, add the following interpretation. General oversight means actions taken to supervise and monitor public and private sector organizations and their policies, plans, programs, and projects to ensure they are in compliance with applicable environmental policies, laws, regulations, and standards. I so move, Mr. Speaker. Interpretation, Mr.
Where did we get the phrase general oversight? Which part of the bill refers to general oversight?
Add. We are adding to the interpretation.
Yes, but you are adding an explanation.
Yeah, okay.
You are interpreting a phrase that has been used. So I just wanted to know where the general oversight has been used.
I'm coming. In the bill.
Functions of the authority, maybe.
Allow me.
Scan for it.
Yes, please.
What you've just done to him, I'm sure that's what in your days in practice they did it to you. Because you have the particular and you can't find it. I'm just doing this to give you space to find it.
What?
Don't, huh?
2D.
Two, which two? Two what?
2D.
Which objective? Objective of what? Which one? Yes, but you said objective. We don't have anything like objective. Mr. Speaker, he's in control of his brief.
Well, I see it at clause
Object of the bill,
clause
of the authorities as well.
clause 2D, and also clause 5A. Clause 2D and clause 5A. It appears in both.
Yes.
Talking about the board, the object of the authority and the functions of the board. So you are right. Honorable members, those in favor say aye. Sorry. Yes, please.
Speaker, I just want to add something. In line 3 of the amendment proposed, we find expression on page 3 that we insert activities. Yes. So there are policies, plans, programs, projects, and activities. Programs maybe we subscribe to the Queen's English. We subscribe to the King's English. So program with MES. But Mr. Speaker, my initial reason for getting up was really, do we need to define the objects? But I'm advised, in consultation with to leave it. So if they have to define general oversight, just to add activities.
Yes, so we are adding activities, projects and activities. Yes, you have no objection to that. All right. I put the question. Those in favor say aye. Those against say no. The ayes have it. We'll move to the next proposed amendment.
Speaker,
Premises.
Add the following interpretation. Premises includes a building, land, ship, an aircraft, a caravan, other than a building or a place used exclusively as dwelling house. All other places, apart from a sleeping place, where you sleep.
Yes. Yes.
Speaker, we are talking about spaces that can be inspected. So spaces, or premises, places, minus places of abode where people live permanently. Other than a building or a place used exclusively as a dwelling house. So if you are producing water in your house, that place can be inspected. But if it is a dwelling solely for dwelling, then it's a private place which Then it comes. Then it ceases to be, solely for dwelling.
It becomes
a container. Yes.
Mr. Speaker, I think this particular amendment is too convoluted. Let's step it down and talk to the sponsors, because it's difficult for me to understand why the definition of a premise includes a building, land, ship, an aircraft, a caravan, not even a vehicle, other than. And Mr. Speaker, I know that there are standards by which aircrafts, for instance, are inspected. There are laws specifically under ICAO for how aircrafts, civil aircrafts are inspected. I'm not sure whether, how do you call it, a Ghanaian authority can automatically, EPA, can just walk to the airport and ask British Airways or something that they want to do an inspection. Because there are laws that govern how aircraft are inspected. So let's step this down and talk to the sponsors as to exactly the rationale behind this. Then we can have a rendition that works. So I would plead with the chairman to step this one also down, please.
The Speaker?
Yes.
We are looking at the law. Okay, all right, okay, thank you. Okay.
So we step it down? Yes, please.
Mr. Speaker, whilst they are at it, to draw attention to the definition that exists in the Narcotics Control Act. I think it's very similar to this, but upon flashing back, it looks like a few things missing from this. Just do a compare. And I think the draft person, Senna, could assist you to achieve that.
Honourable members, I will proceed to yes.
Mr. Speaker, before the curtain is drawn on this aspect of our proceedings, I would want to thank colleagues and thank you most especially, and urge the minister to take judicial notice of the industry of members. The Minister of Environment, I'm saying that the minister should take judicial notice. The Honorable Minister responsible for this bill, who is a member of this House, should take judicial notice of the industry of members, especially when Mr. Speaker has sat through, it's getting to 8, that the members are here to ensure that government business is properly executed. Mr. Speaker, the minister is hereby served an important notice. I thank you.
Honourable members, I defer clause 44, and now we'll proceed to adjourn the House to tomorrow. Yes, I want to get the sense of the House before. Okay. Then, in the meantime, we've ended the consideration stage of the bill for today. Honourable members, the House stands adjourned till Friday, at, sorry?
Mr. Speaker, we have not exhausted the 5 hours.
You've not exhausted the 5 hours. So you want to continue?
Mr. Speaker,
Yes.
An application has been made
That
we've not done the 5 hours. So, Mr. Speaker, we are not in your hands yet.
Which rule are you people referring to? Order what?
Mr. Speaker, the orders are large.
Yes. So I'll proceed to adjourn the House till Friday, 10 o'clock in the forenoon. The House is adjourned.